may be seated. Well, good afternoon and welcome to this special visiting session of the North Carolina Court of Appeals. It's a pleasure for us to be here on the campus of Wake Forest University at this wonderful law school, and it's been quite some time since we've been able to travel and have these special sessions, but they're very important for us as judges because you all are the future of the law, and we care very much about that issue. So it's important for us to be able to come so that you can see some of what we do at the Court of Appeals. Otherwise, you'd have to make the trip all the way to Raleigh, and we have a fairly large courtroom with many seats, and look out and see nobody there coming to watch our arguments when we're in Raleigh. So this is a delight for us. My name is Richard Dietz. I'm joined on the panel today by my colleagues, Judge John Tyson and Judge John Arrowood. And we're going to hear two cases, and then typically at the end, if there are any questions, we can have a short discussion, and I believe there's a reception afterwards. But before we get started, I do just want to thank your Dean, Dean Aiken, and also Professor Graham for helping us organize this session, because as I said, it's very meaningful for us to be able to travel here and participate. So with that, we have two cases on the calendar. The first is State v. Applewhite, and if the parties are ready to proceed, we'll hear from the appellant.
May it please the court, I'm Michael Kesterline from Asheville. I'm here on behalf of Robin Applewhite, the appellant in the first case. I would like to reserve 6 minutes for rebuttal. The facts of this case are that from sometime in 2012 through about mid-2015, Mr. Applewhite, with his wife, worked with a number of women, basically arranging dates on a web page, back page, website, arranging dates for sexual services for money, sex acts for money. The evidence was that Mr. Applewhite controlled almost every aspect of these women's lives, provided housing to them, transportation, food, drugs, heroin primarily. They would provide him with turn the earnings from the sexual activity over to him. They traveled throughout North Carolina, staying in hotels. Sometimes the dates were arranged in hotels, sometimes at houses that Mr. Applewhite had leased, and that the period of time would be that there was some evidence that there was locks on, at least from some of the women, that there were locks on the outside of the doors of these houses, and that there was occasional acts of violence directed towards the women by Mr. Applewhite during this period of time. Now, Mr. Applewhite was charged and was convicted of 27 serious felony accounts, 12 for human trafficking, 11 for promoting prostitution, and 4 counts of conspiracy involving 4 victims. He was acquitted of the charges relating to 2 of the women. He was given by Judge Locke 24 consecutive sentences with a minimum sentence of 120 months. I think a total minimum sentence of 240 years. I think the release date on the DPS website is 2190 or something. In any event, found to be a habitual felon at a proceeding that was immediately after the trial. Mr. Applewhite represented himself facing these charges. That was Judge Locke, the trial court judge, allowed him to represent himself under what we contend is a misapprehension of the law. Judge Locke clearly felt constrained, and you'll see this throughout the transcript. He would tell Mr. Applewhite, as Mr. Applewhite would ask to represent himself, you have an absolute right to do this. And finally, after a competency hearing and a number of other pretrial proceedings and a parade of lawyers, Mr. Applewhite insisted on the eve of trial that he be allowed to represent himself. Judge Locke said, you have an absolute right to do that. That is not the law. The law that
Ferretta, you could certainly understand the trial court that perhaps that's not an apprehension of the law, just the court doing 2 steps at once, which is concluding this is someone who is competent to make that determination, and then once you've made that, you reach that stage in the analysis, and under Ferretta, it certainly is an absolute right.
I understand.
Do you agree with that?
I suppose it would, if we speculate that that's Judge Locke's thinking through this, but clearly when I read this transcript, it seems that he feels constrained because he repeatedly seems to want to talk Mr. Applewhite out of that decision. And he says you have an absolute right. There's nothing at all to indicate that he ever understood that if he felt that Applewhite fell into that gray area, that he would then have the discretion to make a different decision. He repeatedly says an absolute right, and even at the hearing that was just a couple of months before trial, where they're going through the competency evaluation done at Butner, Mr. Applewhite is insisting on representing himself, and the judge talks him out of it and says, well, wait till trial, we'll revisit that again. That is not the process, I would argue, of a judge who feels like he's made that step, made that leap, and concluded that. And the issue here is when a judge is making a decision like and feels that he's compelled to do it, he's not really properly making the decision. He's doing it under a misapprehension of law.
Do you think, Mr. Castelline, there's a difference in the standard between competency to stand trial and competency to represent yourself?
Yes, I do. I think that the Edwards case and the Moran case, guidance from the U.S. Supreme Court, do contemplate that there is a different standard there. There is some, certainly people can be tried, are capable of proceeding to trial, and I don't think there's any question that Mr. Applewhite would meet that standard. But when we start to talk about the competency to conduct a trial of this complexity, we're talking 27 felony counts stretching over years with multiple victims in multiple states, a habitual felon proceeding. It's an incredibly complicated case, and I think there is a different standard.
Is there any argument that he was not competent to stand trial?
I don't think there is. The judge made those findings. He had a report. It seems to fall within the range of what we in North Carolina consider competent to stand trial. What we don't have is anything from the judge evaluating that. I think that Judge Locke appears to find him competent to stand trial, and then as much as he doesn't seem to want to, find that, well, if he wants to waive his right to trial, waive his right to representation, then he can represent himself. And I think that what we have, it's somewhat of an analytic conundrum that comes to us from the U.S. Supreme Court, is we have, for some people, the right to self-representation is an absolute right. But for other people, it's a discretionary right. And the problem is trying to figure out where somebody is in that range. And for most people, that's not a problem. But we have here, Robin Applewhite, according to the competency evaluation, has an IQ of 85. He has behavioral problems going back to elementary school. He reads at a 7th grade level. He has some injuries that can cause him to have a delirium and things like that. And so he may be, we don't know because Judge Locke never did that analysis. We don't have any findings of fact on that point. We don't have any analysis of that. We have Judge Locke simply doing what he feels Ferretta compels him to do, which is grant the absolute right of self-representation.
Does the appointment of standby counsel, does that go to the amount of prejudice that your client may have suffered?
Well, there certainly is. I think the problem that we have is that he's representing himself, and if we read this trial, it's somewhat of it is not a truth-finding trial that's in any sense of the word. It's someone trying very desperately to assert can't control his behavior, isn't coherent at different points in the trial. It doesn't, and he has standby counsel there, who's presumably aiding him, but he's representing himself. He's directing.
You said to Judge Tyson that there's a difference between the competency to stand trial and the competency being competent to represent yourself. Where do you propose that line is?
Well,
have we ever drawn that line in North Carolina?
I don't think anyone's drawn that line, even from the U.S. Supreme Court, and I think that's the problem, is that we have almost a case-by-case basis that we have to make that determination. And again, the state suggests in their brief that if Judge Locke had endeavored to limit the right of self-representation, that we'd be in here arguing the opposite point. But I think that if Judge Locke had said, weighing all the facts and made findings of facts, that this is a complicated case, looked at Mr. Applewhite and said, you have this IQ and these issues, I'm not going to let you represent yourself, I don't think we could ever make a meaningful argument that he falls into that category of an absolute right to represent themselves. And I think that it would be difficult.
If we adopt your contention, don't we have to draw a line somewhere?
Well, I think
This
that-
is not like obscenity. You know it when you see it. I mean, there's got to be some line drawn, doesn't there?
Well, the approach that was taken in Lane, which is our only case on this issue really, because Lane was decided right about the time of Indiana versus Edwards, was have the trial court make those findings. If the, you know, it can be a case-by-case determination, but have the trial court make the findings. And one of the remedies I've suggested here is what the Supreme Court did in Lane 1, which is remanded to the trial court to make those findings. If Judge Locke says, I've looked at these facts, and I'm going to exercise my discretion to allow you to represent themselves, that's one issue. But the analysis that Judge Locke was not the fine-tuned to the case at hand that the state suggests, or being in the, he simply said, you have an absolute right.
Yeah, can I ask you, so the one question I had about that is, because I understand your argument and why, and I agree with you that probably one of the strongest arguments to make for your client is that the trial court was acting under a misapprehension of the law. But we generally have a presumption that trial courts understand the law unless we can find evidence in the record that the court does not. And here, that was the point I was getting at earlier, is this notion of having the absolute right. Isn't it possible to square what the court is saying by saying that the court understood the Feretta principle, and that's what the court was explaining, but it wasn't necessarily saying there's no gray area. It was just making clear that once made the determination that you are capable of representing yourself, you have that absolute right, and it would be a Sixth Amendment violation not to allow you to do that. So what's your response to that?
Well, I think that if we're looking to overcome that presumption, it seems to me that the way Judge Locke appears to struggle with it, appears to be acting on it almost as if he is constrained, seems to overcome the presumption that he knows he's made the proper analysis. And I'd say that when you read the transcript, the number of times this battle between Mr. Applewhite and the judge goes on, the hearing where he basically encourages him to defer the decision until the eve of trial, that seems to overcome the presumption that he's made the decision that you're in that class of people. To me, it seems to indicate that he doesn't understand that he simply has that discretion and could limit if he wanted to. Because frankly, I feel that if he knew he had that right, he'd have made a different decision. I think seeing how he struggles with it.
You know, Judge Locke was able to observe your client and to review and hear him respond to questions. Why wouldn't we give deference to that as an abuse of discretion standard review as opposed to trying to supplant the judgment of the trial court on a cold record?
Well, again, I feel that if he wasn't acting as if he had discretion because he didn't think he had any discretion. I mean, that's the argument. That's the argument there, is that he felt like he had to do what Mr. Applewhite wanted to do, and there's nothing to indicate throughout the numerous pretrial hearings that he ever understood that if he made the appropriate findings, he could limit the right of self-representation in this case.
Is there any question your client repeatedly insisted upon representing himself?
Oh, he absolutely did. Throughout numerous pretrial hearings, going back before the eve of the trial, when he finally allowed him to represent himself, that was a continuing battle, and the judge would say, you have an absolute right, and then try to talk to him. I think at one point, we quoted this in the dangerous and foolish decision, something along those lines, to him. It doesn't seem like that's the position of a judge who understands where his discretion is in that regard. And that's my primary concern, is that when we have a misapprehension of the law and a judge making a decision, this court isn't a fact-finding court, and understand we want to give deference to trial courts, but it seems to me that the judge's inclination is to not let him represent himself, but he feels constrained by Ferretta. And I'd like to talk, if there's no other questions about that issue, talk about the third issue in our brief, which is that the crime of human trafficking is a continuing offense, and I argue that basically the trial court erred in entering multiple judgments.
How many convictions were there of trafficking?
There's 12 convictions for human trafficking, and
From
four separate women.
4 separate women.
And all of the indictments in the human trafficking cases are the same. They're the same. They give the same range of dates and the same named victim, and then they track the language of the statute. They enumerate all 6 of the acts that can constitute human trafficking, and simply recite that. There's absolutely no difference in the indictments. Take, for example, I guess the best example, the indictments for AC we can talk about, but it's the same for all of them. So AC, the indictments allege a date range from December of 2012 until the end of January 2013. 2-month date range, same victim, same exact language. Absolutely impossible to tell, and this was Judge Locke's concern, where the conduct that would be covered by one indictment ends and the conduct that would be covered by another indictment begins.
Now, this is a case of first impression as to whether human trafficking is a one continuous or multiple?
Right. There's no other case in North Carolina that says that. I would argue that it somewhat falls in line with the White case, where this court found that kidnapping was a continuing offense, beginning with the initial confinement and terminating at the end of the period of confinement. If we look at the human trafficking statute, the essence of the offense seems to be this act of coercion, to hold somebody in sexual servitude by means of coercion. Seems to be the essence of it. And then there's 6 enumerated ways you recruit, entice, transport, harbor, provide, or obtain by any other means to do this. But what we have is a period of time where this act of coercion continues throughout this, the providing the drugs, the controlling the situation, and in the same way that kidnapping, it might be sufficient to kidnap somebody to move them from one room to another, but then when you move them to another room after that again, it doesn't create a new offense. But I think the case I put forth in additional authority filed yesterday, decided by our Supreme Court last Friday, talking about multiple assaults and where the demarcation between one and another. And the Supreme Court there talks about the importance of some limiting principle. Now, what we have here is the legislature didn't want there to be a limited principle. They included language that said each act of human trafficking is a separate offense and shall not merge. And that's what the prosecutor used when Judge Locke raised the question that this was possibly a continuing offense. The prosecutor pointed to that section and said that. And then there was a discussion during the charge conference where Judge Locke said, well, how do we tell one crime from the other here? What facts distinguish one indictment from the other? And the prosecutor says, well, I had this spreadsheet, and I think they discussed that a little, and then, but they say, but we don't want to be bound by that. And then they talk a little bit about the fact that some jurors could find that the transportation was the human trafficking, some jurors could find that it was the providing of drugs, some jurors could find that. But what we have is we have a situation where, with regard to the victims, each of the victims multiple indictments with multiple sentences for what seems to be indistinct indictments, no distinction in the verdict sheet, no distinction in the chart, in the instruction, about what act constitutes each individual act of human trafficking. And that's not just an academic question in this case. This is something where the prosecutor says to the trial judge, we could have charged 250 counts of this. And one of the important things about an indictment or the definition of an offense is that it protects the defendant from possible double jeopardy. But here there'd be nothing. If this jury had come back and acquitted Mr. Applewhite on these charges, there would be nothing at all in these indictments that would prevent the state from simply filing a new batch of indictments and trying them all over again, because there's no way, again, as I've said, to say where the conduct covered by one of these human trafficking indictments ends and the conduct covered by another one begins. And it's because of the continuing nature of the thing. I think the operative word in the statute is those 6 acts, entice, harbor, transport, provide, etc., be done with the intent to hold somebody in a sexual servitude, which has another definition that also is the period of coercion and that. And that hold word operates much like the word confine does in the kidnapping statute. Hold is to keep something, again, like confine.
Well,
And
there was evidence of multiple trips, were there not? As to some of
absolutely.
these.
Multiple trips, multiple arranged appointments, and certainly, and no way, I guess, of saying how many times they were done that. But again, if the essence of the offense is the coercion, then where does one, just there's evidence in many cases of multiple movements in a kidnapping, but this court has said that's one offense of kidnapping.
We have a lot of cases that says if the indictment alleges the elements of the offense and the name of the defendant on a short form, generally the indictments are valid. And if a defendant wants greater specificity, that they have a remedy through a bill of particulars to force the state to more clearly define the separate acts. Was there a motion for a bill of particulars filed?
Not that I'm aware of.
Would that not have been the remedy for that?
Well,
if there's some
I
question?
think that would have been appropriate in this case to force the state to make some articulation of what conduct is being charged in anything. But again, at the moment of the charge conference, when the trial judge is asking the state that very question, tell me how to tell one charge from another. I think he uses a couple of file numbers as an example. The state refers to some spreadsheet it has, but then says we don't want to be bound by that. The law doesn't require us to be bound by that, and argues to the jury, I think this is, or argues to the judge, this is about in the charge, about page 1635 of the transcript, argues that there's no problem if some jurors see the 5 acts this way and other jurors see the 5 acts or 4 acts of trafficking that go to AC this way. They can basically pick and choose from the whole array of facts to find, if they find 4 counts of trafficking with regard to AC, then they can convict of 4 counts.
Now, the jury actually acquitted your client as it related to 2 victims, right? 2 alleged
2 victims that didn't testify. They convicted him of one of the victims who was actually deceased. But yes, they didn't convict him on any of the counts of the 2 victims that didn't testify. But that isn't, I don't think that shows that they're discerning some great difference. They just don't have any victims they can look at in those cases. So what we're saying is that a continuing offense is some act that where is the period of interruption in the conduct when the state is trying to prove this ongoing operation that separates one offense from the other, and where is that in an indictment that would protect him from a subsequent prosecution for the same offense. And we just don't
Do
see.
you agree that, as it relates to one act with one victim, with one customer, that would be sufficient for each count?
I absolutely agree that that would be sufficient for each count, but just in the same way that confining somebody to one room would be sufficient for a kidnapping charge, that then when you move them to the, still confined to the second room, that doesn't generate another count. And just as the Dew case decided by our Supreme Court on Friday, talking about multiple assaults. And again, what the court was saying is there needs to be some limiting principle. I think the line they used to limit an offense, because otherwise, the language of this court, I think in Grady, is otherwise the state would be free to chop a crime up into as many charges as it could possibly think of.
Well, let's look at it a different way. Are you contending that the period of confinement being held, that regardless of the number of acts, or the number of days, or the number of customers, if they were held for that period of time, that would only constitute one offense?
I would say that that's probably correct, because
Regardless
otherwise,
of the number of times, events, customers, places. If they're held from here to here, regardless of the times that the victim is trafficked, that would only be one offense.
well, if they're contending that the period of coercion lasts that long, because what would we do if the jury acquitted him and they filed that same indictment again and said, well, this covers different conduct?
Would we not have to presume then that the victim being under the control of the defendant for a given period of time, that's the offense and not the individual acts, times, and places?
Well, again, I think that it seems to work like kidnapping. The kidnapping, the essence of kidnapping is the period of confinement.
Well, once the confinement is over, goes to my question. Aren't you asking us to assume that the control of the defendant over the victims is one event, regardless of the number of acts, times, and places, and customers that occurred within that window?
Well, I think that that's somewhat suggested by the language of the statute. The statute says those acts, entice, transport, provide, etc., must be done with the intent to hold somebody in sexual servitude. So hold is something that has some duration to it. And when we talk about something like that, it seems to take it out of the realm of well, how long does that have to be? And it seems very much like confined in the kidnapping statute.
If someone who was kidnapped was confined and escaped and was recaptured or re-kidnapped, would that not be a separate offense?
Well, I think then the principle that we would apply would come from, like we use in assaults, the line of demarcation. The Supreme Court talks about it a lot in the Dew case, between events or the discernible interruption or something of that nature. I'd like to reserve some time for rebuttal if no one has any other questions.
Yes, I was letting, I haven't used that against your rebuttal time because I know you're responding to Judge Tyson, so we'll save you some time for rebuttal. Thank you.
Thanks.
We'll hear from the state.
May it please the court. My name is Amalia Mercedes Restucha Clem. I'm an Assistant Attorney General with the North Carolina Department of Justice, representing the state of North Carolina. The court should affirm the trial court's findings for the following reason. First, a trial court judge is the best to make fine-tuned mental capacity decisions, and the findings that Judge Locke made on the record are sufficient to demonstrate that the defendant was capable of waiving his right to counsel. Second, The General Assembly could not be more clear that each violation of human trafficking is to be charged as a separate offense. Defendant's
Well,
argument.
did they define what each violation was, however, in the statute? I don't see it in the statute, so when you get to that part of your argument, you're going to have to show me where it is.
Yes, Your Honor, I don't believe that they do define separate offense. Counsel cites a variety of cases that do define separate offense. And, you know, when you look at all those cases, it uses the Blockberger test, right? And when the Blockberger test provides that it was charging two separate and distinct acts, but it found no merit that the Narcotic Act was to be construed as only imposing a single punishment. It said that the plain meaning of the provision is that each offense is subject to the penalty prescribed, and that if that's too harsh, the remedy has to be afforded by an act of Congress and not for judicial construction. And so I think that when we look at the statute, the language in Section A defines an act of human trafficking. It has the two parts of the several acts when matched with an intent to hold an involuntary servitude amounts to an offense of human trafficking. And then you go into subsection C, and that says that each violation of the act constitutes a separate offense. And I believe that's where you would look at that.
Let me ask you this on the threshold question. Same question I asked Mr. Castelline. Is the ability, competency to stand trial is the same test for competency to represent yourself?
I believe that the Godinez case speaks more to that than any other Supreme Court case.
Can you also distinguish Moran from Edwards?
Moran from Edwards. Yes, I do believe that Godinez v. Moran, talked about the competence that was required of a defendant is the competence when they're seeking to waive their right to counsel, it's that competence to waive the right, not the competence to represent themselves. And so when Ferretta was talking about, it goes into a historical analysis of the right to representation and how ultimately in Godinez, there's language about how while the Dusky standard, right, of being competent to stand trial is not appreciably higher, but there is a second step that needs to be taken to make sure that the defendant is waiving their right to counsel voluntarily, intelligently, and knowingly. And that's what's happened in the record here, right? Even also in Godinez, there's a footnote that's right on point because it says that the court, it doesn't mean to suggest that the court is required to make a competency determination in every case where a defendant is seeking to plead guilty or waive their right to counsel. And that competency determination is necessary only when a court has a reason to doubt the defendant's competence. And so we go to your point, Judge Dietz. There was no misstatement of law. Judge Locke, who we know, would have said it's foolish for anybody to waive their right to counsel, right? We know there's the old adage of a fool, person that represents themselves as a fool for a client. It's not a smart move, but it is it's a right that stems with the individual. And so that's what Judge Locke was doing. As he was being directed by Ferretta, he was respecting the individual and that individual's choice, that lifeblood.
What if his IQ was 70?
That's a different story. His IQ was not 70, and there's two capacity hearings in this case, right? One held by Judge Emmons and one held by Judge Locke. Both came up with the same determination that he was capable of voluntarily, intelligently, and knowingly waiving his right to counsel.
His IQ was in the low 80s, is that?
85, yes, Your Honor. But that doesn't, the forensic evaluation showed that he wasn't afflicted in any way by a psychotic disorder, a mood disorder, or intellectual or cognitive disorder. An IQ of 85 is below average, right? It's not below average, it's not 70 or below. And so it is that fundamental lifeblood of the law, individual choice for a defendant to make their argument to the court. And that's what Judge Locke was doing. He was respecting that individual's choice.
Should we give deference to Judge Locke's ruling, or should we review it de novo?
I believe we can give deference to his ruling. I don't believe that there was any abuse of discretion. I think the proper findings are made on the record, pages 15 through 76. Lane 2 only requires a court to make specific findings of fact when a defendant is unable to carry out the basic tasks needed to present his own defense without the help of counsel, right? To
Were
Judge
any
Point-
of those findings challenged? If not, are they therefore binding on appeal?
No, I don't believe they were challenged, and I find it interesting that this case is distinguishable from Lane 2 in that the defendant, Lane, was actually, his capacity to proceed to trial was contested by another expert. It's not the case in this case. And similar to Indiana v. Edwards, that defendant had schizophrenia. It's a severe mental illness. He had incoherent writings that were being submitted to the court. It's not the case here. If there are no further questions on the point of capacity to represent or waive the right to counsel, I will proceed with the fact that, on the second and the third issue, the defendant's argument, as the judges have noted, requires the court to discount the countless violations to which the victims in this case testified and only uphold one verdict of human trafficking per victim.
So one of the best arguments that your friend for the defendant has made is that because of the nature of this crime, there's double jeopardy mischief that could occur if we accept this argument. So what's your response to that concept that it would create so many potential crimes and the state can essentially just choose how many it wants charged in a particular case?
Right. And I don't believe that issue is really ripe for review. I think this is a matter of prosecutorial discretion. So that issue of double jeopardy, of what can they re-indict if he's reacquitted, that's an issue for that day. The issue for today is that there was sufficient evidence to uphold the 12 convictions of human trafficking.
Well,
No-
did they argue what was for each of the 12? Was there an argument about this is the first one, this is the second one, this is the third one, this is the fourth one?
I believe that there was sufficient evidence provided throughout the
That
trial.
wasn't my question. My
And-
question was, did they provide to the jury an argument about the four separate ones?
I would need to go and look back at the jury instructions. The defendant was challenging the indictments in the case and not the actual charge, which I think is distinguishable. I don't believe that they did, but also I can't say for certain. I'm sorry. What I do know that as going back to the question of prosecutorial discretion, right? The court has long held that deference has to be given to a prosecutor's discretion when they're seeking charges. And so the prosecutor has to weigh factors like the likelihood of successful prosecution, the social value of obtaining a conviction as against the time and the expense of the state, and the prosecutor's own sense of justice. And so that court in Rogers held that there was no constitutional denial unless an element of intentional or purposeful discrimination happens. Same with...
Now, isn't this sort of like, though, the obscenity statutes 14 I think it's 90.1, where the Supreme Court talked about in State v. Smith about the 3 sales of 3 separate items could only be 1 sale? Isn't this like that case?
I can respect why it could be like the case, but I think what's important is that we look at the legislative intent. And so the testimony in this case, there was 3 victims that
And
testified.
what the Supreme Court said in that case was that the construction of the statute, in accordance with the general rules, must be strictly construed against the state, too, didn't it?
Right, and that is a case that was brought to our attention late last night. And I believe that only applies, that rule of leniency of strictly construing against the state only applies when there's ambiguity in the statute. And I really do not believe, so to that point, a search of the North Carolina General Assembly will show, if you search Chapter 14, do a search term, there are, of the term separate offense, the General Assembly only uses that 17 times in the Chapter 14. And they're talking about offenses like terrorism, sexual servitude, involuntary servitude, and 5 separate offenses related to the assault, battery, or death of an unborn child. Right? So these are very serious offenses. And so I think when the General Assembly uses that language, separate offense, it is clearly that they're intending to do so for some of our most serious offenses.
And is that more serious than terrorism by bringing a gun or bringing one gun or multiple guns? Haven't we had that discussion in North Carolina in the case law?
We have had that discussion. It was recently briefed last week, right? And there has been a lot of talk about human trafficking and how it is comparable to modern-day slavery. So it is a very, very serious offense. And
Well,
you know, traffickers.
I'm not
yeah.
arguing with you it's not a serious offense, but I'm just asking you, is it more serious than bringing guns to school or those kinds of things?
Yes, I believe there's an argument to be made that it is. Traffickers target really vulnerable people, and they're the easiest
And
to
people who bring guns to school don't target really vulnerable people?
Well, they might not be doing so to actually target people. There's a right to bring, arms, obviously not on government property, but to a certain extent, there's different rights being weighed there. I
But we
believe.
did find in those cases that multiple guns only constitute one offense. Is that correct?
That is correct, and I believe that was because it found that the statute was vague. And I don't believe that if we look to the language of this statute that we can see that it's vague. I think that we're pretty clear in that the General Assembly wanted each violation of the act to be charged as a separate offense. And to Judge Tyson, your point, the amount of what constitutes an act and what amount of time would be a holding for an intent to hold in sexual servitude, it can be the amount of time of transporting one person from one place to another. It could be the amount of time to perform a sexual act. It could be the facts of this case, right? AC was a victim who, the second time that she went to purchase pain pills from the defendant, which she was trying to purchase pain pills because she had, broke her neck in a skiing accident. It's a mother of 35 years old, 4 children, and she is trying to buy pain pills, and he convinces her and talks her into signing the lease for a house that he could use for his girls. She doesn't really understand what the purpose is until after that, after he crushed up, and what he told her was a crushed up Opana pill, a pain pill, was actually heroin. So she snorts heroin, not really appreciating that she's going to have this effect that she says is feeling 100 times the feeling of the pain pills that she has. And there's testimony from each of the victims about what that effect has on people. It makes you feel flowy. It makes you just not care about anything in the world, right? There's a huge opioid epidemic and a heroin epidemic in our country. And so from that point, she snorted the pill. The next thing she knows, the defendant has her cell phone, has her car keys, has her money. That was the recruitment, right? He got her in, and he started talking about how, he could make all sorts of money on her.
Well, is it the state's contention that giving her the pill is one act, taking her cell phone's another, placing an ad is another? Is that the state's contention, that each of those is an act of trafficking?
It can be, yes. And I believe it's in the prosecutor's discretion to determine how those acts are going to be charged. And there's testimony from AC that she was taken to Jacksonville, Greensboro, Raleigh, and Florida, always under the influence of heroin. She had to engage in at least 10 acts of forced prostitution a night, right? She was locked in a hotel room, locked in homes until
Well,
the
was
defendant
each act of prostitution a trafficking offense?
It
under
can
the
be.
state's theory?
Excuse me, Your Honor. Yes, it could be. It's in the discretion of the prosecutor and how to prosecute it and how to charge it.
Going back to Judge Dietz's question and also defense counsel's, if you can find someone for kidnapping, there's not a temporal element to that. There's not a time limit, is there?
No.
So it can be an hour, a minute, a day, a week. One offense?
And one would have to look at the case law on that, but I believe that it goes to those cases that defense cited late last night about State v. Due, where I think the court looks at like a 3-part Rampart analysis on a distinct interruption that occurred. And so there is testimony, and if we go, there's 500 pages of testimony from the victims themselves, 500 pages of testimony from other corroborating witnesses talking about unique incidences that resulted. So another victim, HM, she lived at home with her parents, right? So she wasn't under the victim's control all the time, but she was actually the only victim that testified that was a heroin user daily. And defendant was her supplier, and he would loan her, HM would loan defendant her car in order to do what he needed to do. He didn't want to be seen driven around town in his own car, right? Defendant would often ask her to join the team, and she told him, like, oftentimes that how much money he could make from her, right? she always declined. She didn't consider it morally acceptable. At some point, HM lost her job, and at that point, she was desperate for heroin. Right? She's addicted to heroin. Defendant pounced at that opportunity, and he told HM that if he would allow her to be promoted on Backpage under the name China Doll, he'd make sure that she didn't get sick. She would provide her with the financial and protection that she need. From that point on, HM testified that defendant drove her to 3 separate locations, Greensboro, Raleigh, and South Carolina, often not letting her sleep, requiring to answer every single text message that came in and phone call. If she didn't respond to the calls, she would be left in the hotel room, out of town, without transportation, without food or drugs for an entire day. So I think each time that those trips happen, there's a distinct break in a distinct offense, right? A discernible interruption, excuse me.
If the prosecutor announced that he had documented 240 separate offenses, and this goes to an earlier question too, and let's say he had been acquitted of these charges, would the prosecutor have been free then to go back and bring these same indictments on, quote, other charges?
As I mentioned before, I think I don't believe so. I think that the issue would be brought that day. And so that's the risk that the prosecutor brings in his discretion when he chooses to charge them in these ways. I think that the prosecutor went through that analysis. Like, there was a team of, this case.
Well, what about when he said that he didn't want to be, we've got a chart, but we don't want to be bound by it?
And I think that the case law is accurate in that as well. So there's the case Hartness. Again, the court, when you look at that back and forth between Judge Locke and the prosecutor, State v. Hartness is a case that held that a jury can rely on different facts but still agree that the gist of the offense took place. So Hartness involved 3 counts of indecent liberties with a minor. And the Supreme Court reviewed whether there was error when it used the disjunctive phrase "or" as to what the acts that constitute indecent liberties. Indecent liberties is defined as an immoral, improper, or indecent touching or act by the defendant upon the child, or an inducement by the defendant, or immoral or indecent touching by the child, right? So that's what it went forward. And the court in Hartness held that double jeopardy did not exist because the indecent liberty statute was structured more like the first-degree sexual offense statute. In this case, the gist of, as we were talking about, the gist of the offense is engaging with a person by any means with the intent of holding them in sexual servitude. So while there are comparisons that could be made to the drug trafficking statute, drug trafficking under 9095H doesn't actually include intent language. And intent language is found under 9095A when it's talking about selling or possessing with the intent to sell or possess, excuse me. So I'm arguing that better comparisons could be made to the behaviors and the intent related to indecent liberties could be made to this case, right? The grooming process that's involved, kind of gaining somebody's trust. The fact that the victims are so vulnerable in this case, they arguably can be compared to that of a child. There's ample evidence to support each and every single one of these convictions. And I do think it's telling that the court only convicted on 12 of the 17 charges of human trafficking. So they were able to discern. Hartness held that.
Well, the ones they didn't convict on were for people who didn't appear. Is that correct?
Yes, and they also did convict for the victim who didn't testify, who was MF. MF.
Who was dead.
Exactly. She didn't testify at trial. She passed away in April of 2017 at the age of 25. It's after the charges were brought, but before trial. Multiple witnesses testified that MF was a crack user before defendant introduced her to heroin. And witnesses testified that the defendant treated MF more like a girlfriend, despite being married to the co-defendant in this case. MF had a room in defendant's basement, and the witnesses testified that that room was locked from the outside and could only be locked from the outside. And that the 3 witnesses testified that they had been locked in that room without food or forms of communication, left to get dope sick, right? This flu that is the worst that we'd ever do anything to get rid of this dope sickness. AC, HM, and AB all testified to engaging in 2-girl specials with MF, right? That's when a client pays more money to be with 2 women at the same time. Every time, that money the women earned went directly to the defendant. He's profiting off of these acts. Officer Jones testified to using technology to show the number of times that victims were posted to Backpage. MF was posted 219 times. Victim AC was posted 197 times. Yet defendant was only convicted of 2 counts of human trafficking at MF over a period of 13 months, right, despite all of that evidence. The 3 victims, 3 other witnesses testifying to engaging in acts, right? So I think that there is sufficient evidence presented to uphold those indictments. And with respect to double jeopardy, I think the defendant relies on U.S. v. Simmons in the case, which is an indictment about a tax fraud statute. It said that intent may be manifested by so many acts upon the part of the accused, covering such a long period of time as to render it difficult, if not wholly impractical, to aver with any degree of certainty all the essential facts for which it may be fairly inferred. And it continues to say, the means of effecting the criminal intent are considered to be matters of evidence to go to the jury to demonstrate the intent, and not necessary to be incorporated into the indictment. That's the case here. I think the State v. Hunt has said that the North Carolina Constitution only requires that an indictment sufficiently allege lucidly and accurately all the elements of the offense charged. That happened here. All the other facts are evidence to be to the jury. There's an analogous case here that the court can rely on also is Pipkin. The court was reviewing a failure to grant.
With respect to each individual victim, the trafficking indictment was the same language at the same period of time. Is that correct?
The period of time was different for each victim. The
No,
victims
I'm
did.
talking about for a victim.
Yes,
For
Your Honor,
the
yes.
5 for one or the 4 for one, it was the same period of time. That between this time and that time, they engaged in trafficking. Is that correct?
That is correct, yes. That is correct. And I think Hartness speaks to that, right, and other cases as well. So if we can go to, there's the case in Creason that had said that, it's in Wiggins. Wiggins is a case that found that there was substantial evidence to support indictments of 7 separate sexual offenses. The indictments in that case were found to be proper when they distinguished the offenses charged by their names and the case numbers without pointing to any specific encounters between the defendant and the victim. In that case, there were 7 offenses were charged and indicted, and based on the evidence, 7 returned guilty verdicts. Bullock is a similar case where it was 11 counts of first-degree rape of a child under the age of 13. The charges spanned a 3-month period where the victim testified her assailant engaged in sexual intercourse with her more than twice a week. The court upheld a conviction when the jury was presented with more evidence than the crimes charged. They did the math, right, and they were able to show that in the court there discusses the factors to consider when a jury is presented with what they call generic testimony of more evidence than what's charged, and it looks to the record reflecting that there was no confusion or questions to the jury in trial. There's nothing in the record reflects that the jury was confused as to the charges in this case or what they were being asked to do.
And suppose a state sought an indictment now for some act defendant engaged in, say, with sexual servitude crime, and the state asserts this is not one of the ones that we charged earlier. Where in the indictments, how do we apply double jeopardy in this case? How do we tell which particular acts then are the ones to which jeopardy attaches in this case?
I think that is the decision that the prosecutor made when he chose to charge it in this way. It might bar him from future prosecutions because it is.
How might it bar him from future prosecutions?
Because there is so much evidence presented, and so there would have to be a showing of new evidence, I believe, and there was so much evidence in this case to support those 12 convictions, and so that it's a risk. It's a risk that a prosecutor takes in his discretion, and again, we're weighing those factors of likelihood of successful prosecution. So if the prosecutor goes to try to charge 250 cases, it's a difficult case to try, right? So they're weighing the likelihood of success, the social value of obtaining a conviction as against time. If the prosecutor only sought one count per victim, it's discounting the years in each act that these women testified to. They came into court and a count recounted, and you all
Well,
have
there was
read.
nothing, though, to prevent the prosecutor from saying there was a trafficking in, it was multiple years in these indictments, as I recall.
It was over the course of a 2-year period.
Right,
and
and to say they trafficked it in here, and here, and here, and here. There's nothing to prevent the prosecutor from doing that, is there?
There's nothing preventing him, but I also don't think there's anything requiring him to do. I believe the prosecutor argued correctly that they're not bound by, they're not required to allege those facts, right? That's what the evidence in the jury is for. If he had put it in that way, it would have somewhat limited all of the evidence that was presented. And I think that is the calculus that a prosecutor has to make when we're indicting charges.
I want to ask you about the argument on the prior record level. Do you intend to rely on your brief as to that issue?
Your Honor, with respect to the prior record level, I have requested that the clerk of Cumberland County Clerk send up exhibits 1 through 9. And I would say that there is an argument that the defendant stipulated by silence. That being said, also if the court conducts this de novo review, it'll find that the federal firearm offense, we don't even know if it was out of state. Arguably it wasn't, because Judge Locke didn't check that box. And so NC General Statute 15A 1340.14E requires it to be an out-of-state felony. That box isn't checked. And so it could have been in North Carolina, in state, right? A felony that happened in state, a federal offense that happened in state. The record should show that.
So you don't think there's a need to send it back on the prior record level?
I don't think it's necessary. I believe the record will show that the sufficient evidence shows, as the standard is, that supported at trial and at the sentencing hearing, that will uphold the classification of each of those offenses. And I'm unclear on how much time is left. There's 2 minutes left. And so Your Honor, as I would, unless there are any other questions, I would rest on my brief and thank the court for its attention. Thank you.
Thank you, counsel. Any brief rebuttal?
With regard to the sentencing argument, I would just say I don't think the defendant explicitly declined to stipulate and the box isn't checked, and I think that it's just going to have to be remanded to make those findings. We're not going to infer the judgment. And what I would say, I guess in response to Judge Arrowood, the case cited in our brief, State v. White, which was the finding that kidnapping is a continuous offense, contains the language that when the legislature fails to specify with clarity the unit of prosecution that's going to be construed against the state, and that's this court's holding from 1997. And I don't think the holding of White would be any different if the legislature had included a paragraph like it did in this statute that says each offense of kidnapping is a separate offense. I think that the court would have still reached that same conclusion. And finally, the Dew case was decided last Friday, and it is very instructive in the language that it uses to talk about the fact that the prosecutor can charge that crime over and over again, and the fact that they didn't doesn't change the fact that we need to have some limiting principle in the law to say that. And there the state was making the argument, well, the fact that the prosecutor didn't charge multiple assaults doesn't mean. It says, we decline to leave the ambiguity in the law such that the state may choose not to charge something every punch thrown. And then it says it would to follow the state's reasoning, it would abolish any limiting principle that would give the trial court powerless to limit the state and the prosecution on those things. And that's the concern expressed by our court last week about multiple assaults. And I think the same concern we would have here in this statute with it, where, again, the unit of prosecution is not clearly defined, and I think that creates a problem for this court. I think that way we correct that is we allow one count of human trafficking. The prosecutor chose the way it phrased its indictments. It could have phrased them differently, could have made them distinct from each other, so we know what the offense is, and they didn't do that.
Would you agree that if we were to accept your argument that the fact there were individual victims alleged in the indictments would be sufficient for a separate indictment as to each victim?
I believe that would be appropriate. That's the way we treat kidnapping. And a number of other, I think there's a line of armed robbery cases that talk about when you go into a bank, even though there's a lot of people there, it's one robbery, but if you take money from, I mean, that line for victims seems to be pretty clearly established in our jurisprudence.
Thank you.
All right, thank you, counsel. We will not recess, but we'll stand at ease here for just a minute so the council, you all can feel free